My name is Kevin Moree. I am a partner at McKinney Bancroft & Hughes, a law firm in Nassau, Bahamas. I specialize in tax and trade matters, and I also have a practice that involves civil litigation. If I may refer to it as CESAR, it's not quite a mouthful as the full name. In order to understand why the Bahamian government enacted that piece of legislation, I think it's important to appreciate the context in which it was enacted. And that really begins with this realization that for many years now, there's been a push towards global standards, international cooperation, and that's mainly, if not wholly, related to combating money laundering, terrorist financing, and tax evasion or avoidance. Now, CESAR specifically seeks to address issues stemming from that final category, tax evasion and avoidance. And the EU and the OECD really took the charge in dealing with this matter, and they created a framework. And that framework is widely accepted as the global standard. And in order to satisfy certain requirements under that framework, this idea of economic substance or substance requirements had to be addressed by essentially every jurisdiction, and in particular international financial centers. And as a result of that, CESAR was enacted, and essentially it wants to ensure that businesses are not artificially transferring profits from one jurisdiction to another with the sole purpose of minimizing tax liability. And perhaps to put it another way, is the Bahamian government and every other government who has this sort of legislation wants to make sure that an entity which is being created in the relevant jurisdiction is also engaging in real economic activity there. It doesn't apply to every entity, but the ones that it does apply to, that's essentially the purpose of the legislation. CESAR applies to Bahamian companies and partnerships. With respect to companies, there's three considerations. There's companies which have been incorporated under the Companies Act. There's companies which have been incorporated under the International Business Companies Act. And that is the most common vehicle for foreign individuals who incorporate companies in the Bahamas. And then there are also foreign entities which are registered in the Bahamas, and that's done under the Companies Act. So the first category would be the beneficial owners of those companies. They need to be aware of the obligations. The second category is partnerships, and that's really partnerships that exist either by virtue of the Partnership Act, the Limited Partnership Act, or the Exempted Partnership Act. And so individuals involved in any of those sorts of partnerships need to be aware. And finally, and perhaps goes without saying, any advisors who have clients who are involved in any of those entities also need to be well-versed or get advice with respect to the obligations created by CESAR. The obligations created by CESAR are somewhat nuanced, and it really, to give a general overview, again, it's easiest to deal with it by using categories. So you have the entities, really the companies and the Bahamian partnerships that I've discussed, and they will fall into essentially one of three categories. Either they will be a non-included entity, and non-included entities have no substance requirements. Included entities have substance requirements, and they vary. And then you have holding companies, which are subject to reduced substance requirements. It's actually, it's important, and I think in my experience, this is often overlooked. Um, all entities subject to CESAR must report. And so while a non-included entity is not subject to the substance requirements created by the Act, a report still has to be filed. It's minimal information, certainly compared to the reports required by included entities. But there's still an obligation to make that report, and that's due within 9 months after the fiscal year ended. There's been a few challenges, and I think some stem from the fact that this legislation has been recently enacted. It came into force on the 31st of December 2018. And like all new legislation, some wrinkles have to be ironed out. There's been a minor amendment to the Act, which is already in force. And I understand that there's currently a further amendment that's being considered. But in my experience as a lawyer and dealing with clients, the greatest challenge is associated with determining what satisfies the relevant substance requirements. And perhaps if I can use categories again, just to make things easy, I would say that really stems, one, from determining what is adequate. The legislation has an adequacy test where an included entity needs to have adequate personnel, adequate physical office space, adequate operating expenditure. That test is unapologetically qualitative as opposed to quantitative. And it's consistent through many other jurisdictions, if not all. And it's understandable that it is, because every business is different, every entity is different. What needs to be done for a certain business, the number of personnel for a certain business, which may be relatively small, is very different from a massive multinational conglomerate. So exactly determining in the circumstances of each case is challenging. And the second category is this idea of central management and control. That phrase, I think, is probably well known to most. And again, it's a test which is fact specific, and it's very difficult to advise on, particularly when advisors don't necessarily have intimate knowledge of the workings of a business. And these are not uncommon challenges. And I think you'll find in, again, almost all, if not all, of the jurisdictions that have had this legislation in place for some period of time, there's been a volume of guidance provided to address these uncertainties and to perhaps provide some insight as to what factors should be considered. And most useful is when specific examples are given. And with respect to examples, those usually come in the form of a case that has been brought in other jurisdictions. And that actually provides real insight into how jurists are dealing with this. So those are the most significant challenges thus far, but they're not peculiar to this jurisdiction at all. That's a very important question, and I think actually if I can piggyback off of what I just said about the challenges, the fact that there are a number of other jurisdictions which have addressed many of the challenges faced puts the Bahamas, I think, in an opportune position, because rather than having to reinvent the wheel, the guidance issued by other international organizations and governments, the jurisprudence in other jurisdictions, will allow, hopefully, the Bahamian government to have insight as to what works and what doesn't work, what is going to satisfy the intention, the spirit of the legislation, while also addressing the peculiar instances associated with each business that is subject to the legislation. So I think being able to leverage from the experience of these other jurisdictions should prove to be extremely useful. And I actually think to perhaps put a positive spin on this, and this perhaps is a challenge as well as an opportunity, is again, the pandemic, the COVID-19 pandemic, has created issues specifically with respect to board meetings. the location of board meetings and the decisions made at board meetings are key factors in determining where the central management and control of a business is taking place. You will often have board meetings that are set up in the relevant jurisdiction, and the directors, some of whom may live there and others who don't, arrange to meet in that jurisdiction, which would require those who do not live there to fly. Obviously, the travel restrictions have prevented that. So that's one issue. There has been some guidance issued by jurisdictions as to how that's going to be dealt with. Obviously, the most common solution to that is having virtual board meetings. And then one needs to consider the implications of having a virtual board meeting where only one or perhaps none of the directors are in the jurisdiction that they would usually be in. The other factor to be considered with respect to the pandemic is fundamental decisions are being made on an urgent basis by companies. These are the sort of decisions that the relevant authorities would look at when trying to determine central management and control. Again, these would usually be done at these board meetings, and depending on the complexity of the company, they may happen once a year, twice a year, as many times as is necessary. But now these decisions are being made perhaps in other jurisdictions, and as I said, on an urgent basis, and real consideration needs to give to the practicality of the impacts of this pandemic.